Citing judicial opinions in brief. At its core, a citation to a judicial opinion, or case, consists of four distinct elements. The first element is a statement of the parties' names. This is commonly referred to as the case name, less frequently as the title, style, or caption of the case. The name is how one identifies the case in discussion, or for that matter, in oral argument. Willman v. Ewan. Wisconsin Department of Health and Family Services v. Bloomer. This element consists of the party names, italicized or underlined, so that it doesn't take up an inordinate amount of space. In most cases, the full names are condensed using an extensive set of omissions and abbreviations. For example, first names and second or third plaintiffs are left off. Most cases, although not all, are adversarial, involving at least two parties. Where that is true, the parties' names are separated by a lowercase v followed immediately by a period. Even if the full reference in the original source uses an uppercase v or the word versus or omits the period, it is conformed to a lowercase v period. Finally, this party name element concludes with a comma, which separates it from the next element. That next element is the ID or address for the case. This is sometimes referred to just by itself as the cite or citation. If the jurisdiction has implemented a system of medium-neutral or non-print dependent citation, that system provides the primary ID. For example, 2012 CO 12, identifying the 12th decision of the Colorado Supreme Court handed down in 2012. If the jurisdiction has not yet let go of print identifiers, one or more sets of print case reports or reporters supply the necessary ID, assuming that the cited case has been published. Such print-derived citations begin with the reporter volume number. It is followed by a standard abbreviation of the reporter name. The final piece is the first page at which the decision appears. Thus, 230 CAN for Kansas, 262 is the cite for Willman v. Ewan. 534 U.S. 473, the cite for Wisconsin Department of Health and Family Services v. Bloomer. If the reference is to a distinct portion of the opinion, and in most cases it should be, because American appellate decisions commonly deal with multiple points spread over many paragraphs and pages. If that's the case, this second element should also include the paragraph or page number, or numbers, of the cited portion. The reference to the specific page is often termed the jump cite or pinpoint cite. This is appended to the case ID or address and set off by a comma. So if the decision is published in volume 230 of the Kansas Reports and starts at page 262, and a specific passage being referenced is at page 266, the cite element would conclude 262, 266. In some situations, only one case ID is required. However, as a holdover from pre-electronic retrieval days, some courts and situations require the use of both a primary and a secondary or parallel citation. Most jurisdictions that have implemented non-print-based citation, for example, continue to expect a parallel print citation of volume, reporter name, and page number for each cited case, so long as it's available. Parallel citations are also expected in some states that have an officially sanctioned reporter when decisions appear in that reporter and also in a commercially published regional reporter, with the official reporter site coming first and the regional reporter site appearing second, again separated by a comma. When citing the decision of one state to the courts of another or to a federal court, a cite to its volume and page numbers in the widely used regional reporter system is commonly viewed as sufficient, there being no need to include a parallel citation to an official reporter. As a result of this widespread citation practice, the same decision may have a different citation element when cited within the state from which it originated than when cited in other states or the federal courts. The third element of a case citation is the date, the year of the decision enclosed in parentheses, if that information has not already appeared in the case ID. Let me underscore that if it has not already appeared qualifier, for if the case has a medium-neutral citation, that will include the year of the decision, and so the year need not be repeated in a separate subsequent date element. The same kind of qualification applies to the fourth and final element, the identification of the deciding court. In any reference where the court has already been sufficiently identified by the case ID, there need be no additional court element. But with regional reporters covering numerous states, and even different level appellate courts within those states, and federal reporters covering multiple circuits and districts, court specification must often be furnished. When required, that information is placed in abbreviated form in the parentheses containing the year of decision ahead of the year. The highest court of a state is indicated by the abbreviation of the state standing alone. If that information has already been furnished by the case ID, as for example with a medium-neutral cite to 2012 CO for Colorado, or a print-based citation to volume 253 of the Kansas Reports, it need not be repeated in the date parentheses. Whether to indicate which of a court's several circuits, districts, divisions, or departments delivered the cited opinion depends both on the court and the context for the decision. Which circuit of the U.S. Court of Appeals or which U.S. District Court handed down a decision is always indicated. With a decision of an intermediate-level state court, the information should be included in any setting where it bears on the weight of the cited decision's authority or is otherwise important. Thus, in a state where the decisions of one department or circuit are binding within the unit, but are only persuasive authority with other departments or circuits, the citation should identify the unit issuing the referenced opinion. When citing that same decision in another state or federal court, there's no need to do so. Judicial opinion citations. 4 elements. To recapitulate, they are the party names, the case ID or address, the year of decision, and the deciding court. For further details on this topic, including some points of difference in citation practice and situations calling for a distinctive approach, go to www.law.cornell.edu/citation and review How to Cite Judicial Opinions.